Hi, everyone. Welcome. We'll have you all settle in before we get started. Thanks for joining us. Good morning, everyone. Welcome in. Giving folks some time to assemble into the room, and we'll get started shortly. Happy first day of school, or first week of school to those who celebrate. All quiet in my background here today. Great. Thanks, everybody, for joining. Looks like we've got a great group, so I'll get started with a few others to join shortly. So good morning. Welcome to our webinar, Driven to Distraction, How Fixing Ride Sharing Can Benefit Investors, which is hosted by the Interfaith Center on Corporate Responsibility, or ICCR. My name is Nadir Narain, and I am Director of ICCR's Advancing Worker Justice Program, which focuses on ensuring the rights of frontline working people are respected. Before we begin, I'd like to go over just a few housekeeping items. The webinar, as you'll note, is being recorded. The recording will be available to those who miss us live and for those that would like to share it with their colleagues. Additionally, live closed captioning can be enabled at the bottom of your screen. And later on in the webinar, there'll be a Q&A with our panelists. You can submit questions through the Zoom's Q&A function, also on the bottom of your screen. In this webinar today, we'll focus on recent developments in the Massachusetts rideshare industry and what it means for investors. We're pleased to be joined today by Pricel Polanco, a rideshare driver and activist in the campaign for Massachusetts drivers to win union organizing rights, Abby Taylor, Deputy Attorney General for Massachusetts, and Professor Tom Cohan, an economist from the Massachusetts Institute of Technology. Our presenters will provide background on the recent settlement between rideshare companies and the Massachusetts Attorney General, and the settlement's impact on the company and its drivers. Then we'll open it up for discussion. Let me give just a quick overview of the situation before we jump into the presentations. If you've followed Massachusetts and the rideshare industry, you are likely aware that over the past few years, there have been a series of competing ballot measures, various bills introduced, and lawsuits, including one brought by the AG's office. The various measures brought by drivers, consumers, and the rideshare and delivery companies have attempted to regulate employment status with this industry, create organizing rights and standards for drivers, and hold these companies accountable. Now, tensions around rideshare in Massachusetts have reached a particularly intense moment. On the one hand, rideshare companies are adjusting to new terms under a settlement reached by the Attorney General that establishes basic minimums. The settlement, as you will hear from Abby, also led to the industry agreeing to withdraw their ballot measures around employee classification from the November 2024 ballot. On the other hand, rideshare drivers are moving forward with their own ballot question, which puts the question of creating new union rights for rideshare drivers employed at companies like Uber and Lyft to the voters of Massachusetts. What's important to know is that rideshare drivers currently lack any process under federal or state law to form unions. Further, support from a recent national poll show that 67% of US adults support allowing rideshare workers to unionize and collectively bargain for their pay and working conditions. In addition to the favorable polling, a strong coalition of elected leaders and community organizations are backing the measure, including the public support of the Massachusetts Attorney General, who has supported the ballot initiative and the option for a union as a way to build on the settlement. And of course, we'll hear more about this in the webinar today. Given the broad support, we thought it was important that investors understand the potential risks and opportunities that ballot initiatives create for the ride-sharing companies. In brief, while large price increases over the past 5 years have helped the companies approach consistent profitability, they have not sustainably addressed driver recruitment and retention. Ensuring an adequate, but not excessive, supply of drivers at the right place in certain times is essential for these companies to generate profits for shareholders while ensuring the drivers earn a living income. Collective bargaining with the drivers themselves can enable the ride-sharing companies to efficiently address labor supply, their own persistent operational challenges, and investors' desire to earn a competitive return through sustainable practices. And with that, I'd love to get this conversation started with a driver's perspective. So let me welcome Pricel Polanco, who drives for both Uber and Lyft. Pricel, can you share your views on what encouraged drivers to pursue the ballot initiative?
Can you hear me?
Yes, loud and clear.
Hi, thank you, Andrea. And thank you, everyone who's here today. Buenos días a todos. My name is Ridesharing Polanco, and I'm a rideshare driver for more than 4 years now. And I've been driving for both companies. I'm proud of being a good driver. I like helping my riders. But I do this really for my family. I got 2 young children that I got to take care. And I drive for, over 50 hours a week. And nowadays, I'm getting paid like, I'll say half or less than a half of what I used to make like 3 years ago. And on that note, you can also, see articles and, seeing videos of like companies like Uber saying that, oh, we double our profits every year. Uh, I also have to pay out of pocket for gas, insurance, oil change, and other maintenance cards. Just a few months ago, I was uh, I was speaking out about, it happened to me twice on a road where like I was driving customer. They were getting out of the clubs, which is usually, a big portion of the ride that we do. People, they don't drive because they can get a DUI, so we gotta drive them. And when people are too drunk, they're bombing on their vehicle, and I even had one that pee on my vehicle. And there's a procedure where like you take pictures, stop, don't take no more rides, send them and explain what happens. And usually you used to be taken care of right away, but nowadays it's like they start going around and around and around, so they won't pay a fee. Back in the day they used to pay like up to $175 fee to help you out with not with everything, but because like that week I had to spend $250 twice, one day and then 3 days later twice to clean my vehicle. And they didn't help me. They didn't give me anything. Just took me around, asking questions, asking for a receipt. I took the receipt. Oh, you need a receipt now this way. And eventually at the end they just start replying to me. They just ignore me. And even when I tried several times, they just ignored me and didn't reply to me anymore until I gave up. I got really frustrated that time. So now also we're dealing with this system that is extremely unpredictable. And even in my car, even if I'm in my car for like, 12 hours, that doesn't mean that I get paid for 12 hours. Like just last night, I went out and, I took a spin for like 4 hours and I get like 2 rides in the whole 4 hours. And I was contacting my friends. I say, hey, you guys ain't getting any rights? I say, yeah, I got a couple rights, but like they're not coming out. So we headed to the airport. In the airport, we started spinning around for another 3 hours because they had the parking lot closed. Like the police had the parking lot closed and had us spinning around the the vicinities of the airport, and we spun around there for another also 2 hours. So that's like 5 hours and only like 2, 3 rides, a whole night. I had to like come back home with $48 on a whole 5 hours. That's just ridiculous. Between the cost of the that I have to absorb and the unreliable system, I haven't been making the wages they promised by the settlement. They say like 32 something, but that's not really happening. Especially after all everything that I have to spend. Gas and all that. It really comes down to like way less than minimum wages. Um, and for drivers like me, that make a struggle because we are forced to go out and work, like even sometimes up to over 70 hours. That personally, I consider that slavery. Like I got two kids, and I don't get to spend as much time as I want to with them, because whenever I'm back home, I need to go back to sleep so I can go back and drive. And you know another factor is that, like, every other driver that I know, including myself, is got like back pain from being you know, attached to their vehicle for like over 12 hours a day, every day. I got to go out every day. Sometimes I feel sick. Sometimes I feel like I'm so tired that I can't no more. So I take a day off. I take half a day off. But I can really afford to have a day off. I got to be out there every single day of the week, 7 days a week, for me to even just come out afloat. Um,
Yeah, thanks,
so
Parcel. I think you make an excellent point there in terms of the settlement, of course, hits on basic minimums, but that ability to take paid time off when you're sick, for example, is not covered. And therein comes potentially the benefit from this ballot question around being able to unionize. Can you just share a few words on the ways in which you think the ability to unionize as rideshare drivers could be beneficial?
Yes, I just wanted to also remark that in the right that we actually go out and take, if I go and
Mm,
ask the customer, hey, how much did the app charge you? And they're like $100.
mm,
Well, out of $100, they pay me $30, and I
mm.
had to pay for everything, and that's like more than half of the rights that they take over the 50% of the fare. So I believe if with a union will give us the right. It's just funny how, like, every other worker, not just in Massachusetts but all over, like even police, nurses, teachers, they
Mm,
have the right to unionize, but us drivers are singled out. We are helpless. And like it happened to me. I got deactivated for a whole year, and that was a whole year that I contacted Uber. I got my conversations, my emails, my phone calls, all everything recorded. A whole year contacting Uber, and they just took me back and forward with no results, and they didn't even have a reason why they had deactivated me. And when that happened, I had to turn over to Lyft, which is, we all know, it's a smaller company. They even pay less. So
mm.
that for me, that means that I had to go and work an extra 20 hours of everything that I was working, and it was just being out there making just a portion of what I used to make. So I believe having a union will give us, we have somebody to speak out for us, because as a single driver, I don't see myself being heard by nobody. Nobody cares about my business,
Mm.
or any other drivers, in particular. But if we all can come together and we have a voice, we have a representation, somebody that know our rights, because most of the drivers, we don't know our rights, when it comes to, like, the actual work and all that. And but if we have somebody to actually, speak out for us and look out for us, and we have a seat on the table to bargain about our wages, this is what we need. We're not asking for gold here. It's just to survive. Because what we're doing is slavery. And then, we got to involve human rights here too. Because like I said before, there's a lot of drivers that have back pain. On the past 3 months, I've been to like 18 different chiropractic sections for my back. It's just all stiff and painful just to get it out of bed. Um, but I believe, with the union, we can solve that. The union, by the way, was the one that helped me get reactivated. They went through my conversation, the 32 BJ. They went through my conversation with that, and they told me step by step what I needed to do, and they figured it out. Uber figured it out. That was a mistake that they made,
Mm.
and and they got pretty much just forced to, like, put me back on the road.
Yeah. Thanks, Parcel. I think it's important to make note of that you needed that extra support in order for the company to be attentive. and really appreciate you taking the time today to join this conversation and share with investors the driver perspective. It's really helpful for us to understand what happens to people in that driver's seat. So really appreciate that. So let's now turn to Abby Taylor, Deputy Attorney General for Massachusetts. Abby, would love to hear how the agreement with rideshare companies came about. How did your office reach the settlement on the minimum standards? And would love to hear your thoughts also on why the AG's office is supporting the ballot question, especially in light of the settlement. So over to you.
Sure. Happy to talk about the settlement and also talk about why we see collective bargaining rights for drivers as an important next step in the work that our office is doing to ensure that drivers have the pay, benefits, and worker protections that they deserve. So the settlement, just to sort of give you a sense of the broad terms, includes a minimum pay standard of $32.50 per hour. That includes time that a driver spends to pick up a rider and the time that the driver spends driving the rider to their location. It also includes a suite of benefits and protections. It does, in fact, include earned sick time. The earned sick time just hasn't gone into effect yet. That'll be in effect in November. So earned sick time, a health insurance stipend so that drivers can can buy into health insurance programs in the Commonwealth, and a stipend to pay into our family and medical leave program here in Massachusetts. It also includes annual reporting requirements to our office, and it will stay in effect in perpetuity so long as there is not a change in business practices or a change in the law that renders the settlement agreement insufficient. Just to sort of step back even a step further, the background of the settlement was, as was mentioned at the top, a lawsuit that we brought seeking a court ruling that Uber and Lyft drivers are employees under Massachusetts wage and hour laws. Frankly, we were very confident that we were going to win that lawsuit, but that victory was going to be short-lived. And that was because of the other ballot initiative that could have appeared on the ballot this cycle in 2024, which was a company-backed ballot initiative that would have permanently classified drivers as independent contractors. And it would have locked in wages that were $10 per hour less than that we secured in the settlement. We really felt like this was unacceptable for Massachusetts drivers, and frankly, not good for the companies either. And so with our agreement, the companies withdrew their support from that ballot initiative, and the ballot initiative did not move forward. Of course, the initiative that is moving forward is question 3, which would allow for collective bargaining rights for drivers. And for us, this is the natural extension of the settlement agreement. The settlement agreement it establishes a floor, a minimum in terms of pay and benefits and some protections. It was silent as to the question of classification, but it's our understanding that the companies plan to continue to classify the drivers as independent contractors. And as long as that's the case, there are really only 2 ways to ensure that drivers are treated fairly. One is through the oversight of our settlement agreement, and that's important, and we'll take that job very seriously. But the other one, and it's a really important one, is to give the drivers the tools that they need to advocate for themselves and to negotiate with the companies in areas that may not be covered by the settlement agreement, and also to build upon it. So, Parcell mentioned cleaning costs. That's not something that our settlement goes into in any great detail. Maybe that's something that could be taken up through collective bargaining, and there may be others as well. When it comes down to it, in terms of why we support the ballot initiative, drivers need change over time. What is important to them, what their working conditions entail, that may change over time. And it's important that drivers are able to negotiate for what they want and need with the companies at any given point, and that they're empowered to use their voice in an organized way. It will also help ensure that the settlement agreement itself remains relevant, that it can stay in place and provide some stability both to the companies and the drivers. If drivers have the ability to collectively bargain to build upon the settlement agreement, that will ensure that the settlement agreement again, sort of continues to be, in our office's estimation, relevant in terms of Uber and Lyft's business practices moving forward. I know you're going to hear more later in this webinar from people who are smarter than me on this topic about why collective bargaining is good for business. But at the end of the day, the way I see it is that it is an organized way that drivers can engage with the companies and ensure that what they most want is taken into account in the company's business practices. That leads to longer term job satisfaction, and it leads to stability for everybody, for the companies, for the drivers, and for regulators like us. And that is a good thing for drivers, it's a good thing for the companies, and it's a good thing for our consumers here in Massachusetts who depend on these companies for really important transportation needs. So that's kind of how we see this as an important extension of the work that we've done with the settlement agreement. And I will be very happy to entertain any questions that you all might have.
Thanks, Abby. I think that's really helpful in terms of explaining that the settlement establishes a floor, right? And that there's this opportunity to build upon it so that drivers are treated fairly, and the end result being sustainability for the companies and also for investors and consumers. So really appreciate your thoughts there. We're going to turn now to Professor Cohen. Thanks for joining us. Tom Cohen is a professor at MIT Sloan School of Management and the Institute for Work and Employment Research. Tom, would love for you to help us understand the impact of the ballot initiative on investors.
Well, thanks, Andrea. It's wonderful to have this conversation. It's timely, it's important. I'm glad to comment on these things. And I'll just make a few points about why this is in the interest of investors and the companies themselves. First of all, we need to understand the economics of this industry. This industry has high fixed or flat costs, both for the company and for drivers. So once a driver is logged on, the utilization rate is the term that's used. That is the proportion of time that a driver is logged on to the platform when the driver is actually driving a passenger or picking up a passenger. That generates mutual benefits. The more the drivers are out there doing that, the more they earn, and the more they earn for the company. So having a stable collective bargaining partner that enables the company to engage in an ongoing dialogue with drivers over how to make the best use of their time may help the company avoid the need to offer very expensive incentives for drivers to stay available. While the companies don't disclose how much they spend on incentives currently, it's likely to be a very substantial amount, especially in the big cities. So there's potentially big dollar savings to the companies if this issue was put on the table for discussion with the drivers and they worked out better ways than just incentives to stay on the road for reasonable amounts of time. Secondly, there's clear evidence from lots of other industries that unions reduce turnover and they increase the quality of a job on a number of different attributes that workers value. We just heard our friend Priscilla talk about what is important to him on this job. Certainly wages and benefits, but also respect, the ability to have an issue or a complaint that he experiences handled through a fair process, the ability to challenge if he's taken off line to find out why and to deal with it. Well, that's what unions do. They provide workers a voice in shaping how they work and appealing what they might feel is unfair treatment via dispute resolution that builds trust between the parties. Collective bargaining and an arbitration process that's fitted to the specifics of this job and this industry would increase trust. And all of these improve job quality and they lead to lower turnover. Again, that's a mutual benefit, a mutual gain for both parties. Third, there are big reputational effects involved here. As you indicated, Nadira, the public support for collective bargaining is at an all-time high. In general, the American public, just about 70% now, say they support unions. And you indicated the evidence when you're asking about drivers in particular. 2/3 of the public say that they should have the right to collective bargaining. So a company that would campaign against allowing workers to form their own union risks further alienating the public. And indeed, the more companies try to dissuade the public from supporting the initiative, the more they are at risk to a public backlash that hurts their reputation in the minds of the public and their riders, as well as their drivers. A fourth reason that this is in the interest of the industry is that this unique bill sets up a bargaining process that is sector-wide. It's not company specific, and that's very important. That may sound like a technical labor relations feature, but this avoids having one company that might unionize experience what could be a cost disadvantage if they have to compete with non-union companies that are not organized. And that's especially true for possible future new entrants into the industry. By having this sector-wide and having the workers need to establish evidence that they have a proportion of workers in the industry that want a union, and then they bargain with these companies collectively as an industry, it will do what we call in labor relations, take wages out of competition. This really works very well in this particular kind of setting, and it's a very innovative feature of this initiative. We don't see this anywhere else in the country, and so once again, Massachusetts could be a model for what others do in other areas. And then the final point goes back to what Abby said. The Attorney General's agreement establishes minimum standards for wages and these other several benefits. But historically, what we want collective bargaining to do, as we have done in other industries, is to allow the parties to build on these minimums periodically over time and to negotiate what in our trade we call efficient bargains. That is, agreements that best reflect the interests of both the workers and the companies. And through dialogue and through negotiations, they're able to reach agreement for them rather than leave it to government agencies or legislators to try to update these provisions over time. That's a very inefficient way to do it. It's very difficult. It's subject to all kinds of political processes outside the control of the companies and the drivers themselves. And so this is a much, much more efficient way to keep these standards relevant as economic conditions change. And it allows the parties to tailor the provisions to fit their particular needs and their priorities. So I like the design of this initiative. I like the structure for collective bargaining, the process of resolving disputes through collaborative discussions, and the ability of companies to save money by not having to guess through their algorithms what kind of incentives they need to put on the table to keep drivers on the road for a reasonable period of time. So those are the reasons why I think it's good for the investors, it's good for the companies, it's good for the drivers, and it's good for good public policy for the state of Massachusetts to serve as a model for the rest of the country. Thank you.
Thanks, Tom. Those are really helpful reflections on building the investor case. Really appreciate the clarity on those points that you made. The conversation is open now for questions from our audience. So if you have a question, please include it in the Q&A box on your screen. Pricel, maybe we'll call you back on screen here to talk about, for you, for other drivers that you've been in conversation with, what kind of issues do you expect to address in collective bargaining with Uber and Lyft and others?
Well, first is the disconnection without, system to tells you why you were disconnected, and some kind of system put like, you can just like run a red light and you just get disconnected. In my case, I spent over 50 grand and on a nice vehicle and nice insurance, expensive insurance and all that. And I believe like if I go and run a red light or something like that, a speeding ticket, just a simple thing like that cannot just, it's not fair for me to get disconnected from a main source of income because of one single thing. Maybe have some kind of system where like, maybe a warning, 2 strikes, and then you out or something like that. Or like, did something really happened there? Let's investigate what happened, some kind of system. But the way it is right now, you just get disconnected without advice, and a lot of the time they don't even tell you why. Another one is, well, we got the most important one is, which is disconnection out of the way. Now we got the wages. We do this for a living. We need wages to support our family. We need wages to actually keep doing this because there's been a time where like I get like the money taken out of the $170 worth of toll out of my account, and that's what I made last night. And I don't even have money for gas to go out and make some more money, So we need an increase on the wages, because it's not regular that, with the years, we have our wages cut down to like less than half, where like everything, the living costs just keep going up. It doesn't make sense to me. In all other jobs, you see that you get incentives, you get, raises and all that. There's a way up for you to keep building and keep making a little more, or at least, feeling, some kind of balance and feeling stable.
Mm-hmm.
But in this, we're just getting cut little by little. We're like, right now, we're making less than half. And another one is, like I mentioned before, is some kind of protection for the drivers, not only when it comes to deactivation, but also, against like things like something happened. Like if I go into a car accident, well, Uber is not going to cover me. I'm on my own. And, and that would just take me out of the game completely. If I go and a customer, pukes on my car, that takes me out of the game for that day, maybe the next day too, and I gotta pay extra money to clean it. So now I'm working for free because I gotta go and pay, pay for the cleaning fees that wasn't even my fault. So those to me, those are the main ones.
Thanks, Priscilla. And I've heard from a number of Uber drivers the same thing that you brought up in terms of deactivation, which seems to be a real major issue. Great. I have a question for you, Abby. One concern that critics of ride sharing have made is that Uber and Lyft cause increased congestion with all of the associated harms. How do you think the settlement, or if adopted, the collective bargaining mechanism will affect congestion?
Well, I'm not sure. I see congestion as sort of a major issue one way or the other. Certainly congestion is a problem in Massachusetts over many years. And I think that these companies do provide important transportation options for people. I think we need to work as a public policy matter on all sorts of ways of easing congestion. But I'm not sure I see either the settlement agreement or the collective bargaining solution as affecting that one way or the other. I think, that at the end of the day, these remain important transportation options for our consumers, and at the end of the day, consumers will continue to utilize them. So I'm not sure I see much connection.
Thanks, Abby.
I wonder if I could comment on that, Andrea, because I agree with Abby that it's not something that public policy and government, the state could deal with effectively. But if you have a viable collaborative collective bargaining relationship, then you would set up a joint committee on congestion, because again, it's in the shared interests of the companies and the drivers to not be caught up, as Priscilla talked about at the airport, with too many cars there, nowhere to park and causing all kinds of other traffic problems. They lose, the companies lose. And so if there was a dialogue, an ongoing dialogue, where they could work on that problem together, they would find their own tailored solutions and adapt them and test them and see where it goes. That's the best of labor management relations and collective bargaining that we see in other companies and in other industries. And it's entirely possible and would be beneficial here.
Thanks, Tom. That's really helpful. Another question for you here, Tom. How does opposing collective bargaining open up investors to risk?
Well, the big risk is, again, that there's more conflict, there's more turnover. The companies will lose more money as time goes on. If they're paying wages that, even though the minimum has been set, even today might not be adequate, then they're not going to get the quality of drivers or the number of drivers. So their investment in Uber and Lyft and other ride service companies is at risk. But in addition, these companies are very vulnerable to public sentiment. They are the face of the way people move around, and everybody knows Uber and Lyft, they're household names. The evidence is it's the household names, even if they're good employers, are the ones who pay the consequences of problems like this. If the public gets disaffected with them or feels that they're not treating their drivers fairly, then the companies are going to begin to suffer losses. And we know from all kinds of research that there's a positive relationship between the satisfaction of the workforce in the service industry, that is the drivers, and their customers. And you really want that positive correlation to be strengthened, not weakened. And that's what having the drivers feel they are respected, have a process for a voice for dealing with whatever issues they are experiencing, and periodically adjusting their terms of employment will provide.
Great, thanks, Tom. Abby, I'm going to turn next to you here. There was a Boston Globe article this morning discussing drivers' efforts to support the ballot initiative. Uber said that it doesn't plan to oppose the ballot initiative, but it plans to remedy some of the concerns through the state legislature. Is the legislature able to revise or overturn the ballot initiative? Any thoughts there?
So the legislature can certainly change the law as it sees fit, including statutes that were enacted through ballot initiative petitions. What has happened historically is that the legislature is disinclined, for good reason, I think, to overturn something that has been, democratically voted on and decided by the people. But the legislature from time to time is inclined to enact sort of small fixes, changes around the edges to make laws more workable in the real world. And so that certainly happened with several ballot initiatives that have been passed in the past, particularly where both proponents and regulated entities are sort of all on board together with potential changes that may need to be made, again, where things would need to be sort of more workable in the real world. So without knowing the specifics of kind of what Uber has in mind, and without being in the legislature myself, I can't really comment on how likely the specific change that they would like to see happen would be likely or not. But I can say that it's not unprecedented for the legislature to make some changes to statutes enacted by ballot initiative after they pass in Massachusetts.
Great, thanks, Abby. We've got a great engaged audience here. So here's another question. What measures are being taken to prevent algorithmic discrimination? There have been instances where Black drivers were not recognized by facial recognition features in apps like Uber, locking them out of the app for days and preventing them from working. Could this issue be addressed through collective bargaining agreement to ensure fair treatment for all drivers?
Certainly it can be addressed in collective bargaining, and this would very, very likely fall within the scope of mandatory subjects of bargaining, because the algorithms themselves affect the working conditions of the drivers. And that's sort of the general principle, that it has to fall within something that influences the drivers. Certainly, if I was a supervisor and I discriminated against a driver, then that would be covered under the law, because I'm an agent of the company, a human agent in this case. The same is now in the various agencies and the courts coming along to say that algorithmic rules that affect working conditions are also subject to negotiations. And in fact, I've worked on these issues for years in terms of technologies. And we know that the technologies, when they are co-designed with worker voice and they're fitted to the particular conditions that people are experiencing, they have the best effects both for the company and for the workforce. There's a long body of research that has come out of MIT and lots of other places that demonstrates that. And so this is just another example of if we use technology effectively, it can benefit both parties.
And I'll just add as well, from an enforcement perspective, certainly this was not a topic because of the settlement agreement, which was really based on wage and hour violations, not based on discrimination allegations. But our office certainly takes the position that algorithmic discrimination is discrimination, and that may be able to be enforced under our state civil rights laws. So I think this would be something that our office might be interested in taking a look at through a separate channel as well, in addition to Tom's good points about how that might be able to be addressed through collective bargaining. But I do think he's absolutely right that courts are starting to see more civil rights lawsuits that involve algorithmic discrimination, and whether the discrimination that occurs is by a human or whether it is by a machine, it's still discrimination under our state laws. That's certainly how we look at it in the Massachusetts Attorney General's office.
Great, thanks for that great question. And thanks, Tom and Abby, for those responses. Another question here. Currently, Uber doesn't disclose the total amount that drivers are paid in aggregate. They report only how much they receive from passengers, which is a point that Purcell made, including people ordering from a restaurant. How much they keep in revenue, which doesn't enable readers of their financial statements to distinguish payments to drivers from payments to other parties, such as restaurants. Also, Uber still accounts for driver incentive payments in a way that leads some of them not to be disclosed. Will either the settlement or the ballot initiative shine more light on how much Uber spends overall to obtain driver services?
So I think this is a good example of where collective bargaining can sort of assist in going further in terms of what the settlement agreement requires. What the settlement agreement requires is that Uber and Lyft provide transparency in terms of pay that drivers will receive. And again, that's because the concept of the settlement agreement was based on our wage and hour laws and what's required there. What's required there, the analogy there is a pay stub. So you need to know how much you're going to be paid for the work that you're about to do. And then you need to know how much you were paid after you do the work. So the settlement agreement has specific requirements around that, around ensuring that drivers understand how much they're going to be paid and then how much they are ultimately paid. I think this is sort of an example of where, to the extent drivers are hungry for more information about how the companies allocate the money that they make on any given ride, that could be something that could be a topic for collective bargaining.
And certainly, we, again, have a lot of evidence that pay transparency in all its dimensions is something that's very important for individual employees, workers, and it also has benefits to companies. The more transparent, the more people understand the full set of factors that influence their pay, the more satisfied they're going to be, the longer they're going to stay with an enterprise, and the more productive they are. That's very clear. And in collective bargaining, there are very well-established parameters for requesting information from the employers about how they calculate compensation and where the revenue flows are going. So I would expect that to be a very central issue in collective bargaining. And again, it's not that unions come in and, you know, bang on the table and say, I want X and Y. Today's bargaining is very sophisticated. It's information intensive. The parties sit down, and if they can agree on the database that they need to explore and understand, then they can put a labor and a management subgroup together to say, let's figure out what the relevant data are telling us. And now let's go and bargain over it with an understanding of what the data are that we're dealing with. That's the modern approach to collective bargaining. We train people in doing this. I facilitate these kinds of processes. Many others do as well. It's not just what I do. That's the modern approach to collective bargaining. It's not just going in and demanding without information what needs to happen. We can make that happen in Massachusetts. There are a lot of resources here and a lot of experts who can help the parties build positive employment and labor management relationships.
That's great. Thanks, Tom. I think we're nearly at time, and I don't see any more questions. So what I'm going to ask is for each of you just to state in a minute or two any last words you want to leave with our investor audience as we think about the question on the ballot coming up in November and on the settlement agreement. So Pricel, I want to start with you to share any last thoughts that you want to leave the audience with.
Hi. No, there is a question that I get asked a lot by drivers. Between the questions that I get asked by different drivers is like, when is the settlement that they did? They say that they were gonna they did a settlement for like almost 180 million, and a lot of people are talking like, where did that money went? They haven't seen it. And that also that the $32 that they were, that they were promised, like they don't see that effect going on. Like I said, like just last night, I was for several hours and going in different parts of the city, and I only had like 3 rides. So, and some of the rides didn't even met that, it was like an hour away, or I wait for an hour and didn't make that, not even that was promised, the 32 something.
Thanks, Priscilla.
So
Abby, you wanna? Yeah.
Those are just the questions I have, and because, I get asked a lot.
Thanks, Priscilla.
I'd be happy to answer those questions and also include some parting thoughts. So in terms of the $175 million that the companies are going to pay pursuant to the settlement agreement, and thank you for bringing that up because I hadn't mentioned it at the outset, that money is due to come to our office in January, and it is our plan and approach for the vast majority of that to go straight back into drivers' pockets. We are still working out what is sort of a fair and efficient way of distributing those funds, based on sort of like criteria in terms of how much people have driven and how much they have made over time. And you should expect that announcement will be coming in the next couple of months in terms of that distribution. But the money itself, we don't have it yet. It comes to our office in January, and then we will work as quickly as possible to distribute it directly to drivers and with transparency as to what the criteria are in terms of how we make those determinations. With regard to the 3250, I want to be clear that pay standard just went into effect at the beginning of August. So that was when it went into effect. it is a minimum amount for the time that it takes after a ride is assigned to a driver until the time that a rider is dropped off. We very much tried to incorporate the best estimates we had possible in determining that 3250 in terms of time that drivers spend waiting for rides. You know, that math is hard to do and it is imperfect. And that's, I think, another reason why collective bargaining to build off of that minimum is really important. And I also would say that, you know, our office certainly wants to hear from people if they feel like that is not happening. But that's the minimum, and it is for that time period. I think that it is just true that there may be times when if somebody is waiting a very, very long time for a ride to be assigned, that, you know, that 3250 may feel like it is stretched very thin. And I think that's another piece of this puzzle that that collective bargaining could help to address. The other thing that I want to say that just sort of relates to this is the very different functions I think you've been hearing throughout this, that the settlement agreement plays and that collective bargaining plays. You know, the settlement agreement was a confidential process. It was just between us and the companies. We couldn't engage in stakeholder, you know, feedback from drivers or others as a matter of law. And it really was to establish certain minimum pay and benefits in order to feel confident that even though the companies were going to continue to classify the drivers as independent contractors, that they were getting minimums that every worker in the state is entitled to under our wage and hour laws, that those minimums were set. And so that was a process between us as a government regulator and the companies. The process that happens in collective bargaining is between the drivers and the companies, and it's about building on those minimums, and it's about prioritizing the things that are most important to the drivers. And that's really important both for the long-term effectiveness of the settlement agreement, but it's also really important for the companies, for the drivers, and for the consumers in making sure that those needs and interests are best met. So I think that the sort of different function of the two, you know, of the two processes, I think is really important to point out here. Thanks so much for having me. I really appreciated the opportunity.
Thanks, Abby. Tom, over to you.
Well, I think it's very important that we put this particular initiative and opportunity in perspective of what's happening around the country. We've been studying this, and I've been engaging labor and management around the country. We are in an era of worker activism and an upsurge in interest in joining a union, forming collective bargaining, getting a stronger voice, reducing the gap in the size of the voice gap that exists today, where workers want more opportunities to influence how they work and how their company operates, and to be proud of their companies. They're not anti-Uber, they're not anti-Lyft, they're not anti-Starbucks for that matter. They want to be proud of the services that they're providing and that their employer supports. And so this is part of it, and especially young workers are driving this interest in getting a stronger voice. So this is part of the zeitgeist that we're in now, and it's going to continue. The employers I talk to all over the country say, we don't see these expectations going away. They're just going to be part of how we need to manage. And the most important new development in management skills that we need to teach in our business schools and that companies need to develop is, how do we manage a collective process? We're good at managing individuals. We've taught leadership around that. We now need to develop deeper skills in how to work collectively with other parties with respect and with effectiveness. So this is a very important experiment. Massachusetts has an opportunity, as I said before, to once again be a model for innovations across the country. And I guarantee you that if this initiative passes and the processes that designed here are put in place, we're going to see other states do the same thing or attempt down the road. And I think that would be good for the country. It would help improve the lives of these people who are providing these key services, and it will help solidify the future of these companies and the industry in the services that they're providing. Thank you very much for the opportunity to talk about these issues.
Thank you, Tom. Pricel, Abby, Tom, great to have you. Thank you for this conversation and for all that you've shared to help investors understand the state of play in Massachusetts around the settlement and the ballot initiative. Thank you to our audience for joining. Thank you for your engagement and your questions. We'll be sharing the recording shortly with you all to share with your colleagues or for anyone that missed us live. And I just want to end here with some closing quote, and the quote is actually Pricel from you, the statement that you made earlier. We bring folks home to their families, but we struggle to support our kids. We want the option to join together in a union, like nurses, bus drivers, and like most other workers, to negotiate for better pay, working conditions, and job protections. Thanks everybody for your attention today, and we'll be in touch soon. Thanks everyone.